Duffney, who's approaching the podium as we speak. Mr. Duffney, please introduce yourself to the court. Thank you, Judge.
All right, folks, buckle in. This is where the dance between defense strategy and courtroom patience begins. Watch closely for the subtle cues the judge gives, and the not-so-subtle ones.
Today's date and time set for probable cause conference. I was just appointed on this matter yesterday afternoon, so we are asking for a brief adjournment for discovery and for plea negotiations. At this time, there's also a bond violation, or
there is.
Yes, Judge. So I spoke to Mr. Duffney. He went to community corrections yesterday at 4:20 p.m., but he did not have the money to test, so he was unable to.
Quick legal note. When the judge asks if a defendant will test clean, they're talking about court-ordered drug testing. Admitting you're on a prescribed medication can be fine, as long as that medication isn't a cover for something else.
We did discuss today. He's going to go immediately to community corrections after this. I do have an email from community corrections to confirm that he was there.
Is he going to test clean?
I believe so, Judge. Yes. He's on what?
Are you going to test clean?
I'm on Suboxone. Yeah. I'm prescribed Suboxone.
You're prescribed it? I'll pass it. He needs to get over there and test and then come back.
So thank you, Judge.
I'm not doing that anymore. Takes a lot. Just go on. Court recalls the case, People versus Justin Duffney. Yeah.
Good afternoon again, Your Honor. Good morning, Chief Assistant Prosecutor appearing on behalf of the people.
Can I bring it back on the record with Mr. Duffney? Justin, please state your name for the record.
Justin Duffney.
I've seen the results, Judge, and I have gone over them with Mr. Duffney.
He doesn't have a prescription for cocaine.
Bond revoked. Translation. No more freedom while you wait for trial. One slip-up, even something small, can change your pre-trial status in an instant.
Okay, Mr. Allen.
I would assume no. Gonna be all right. Gonna be all right.
All right. I'm going to adjourn the probable cause conference to August 14th, 2025, 9 a.m. His bond at this time, given the violation, his bond is revoked. Defendant's remand.
Thank you, Judge.
Good morning, Your Honor. Assistant Public Defender Carson Lobes on behalf of Mr. Brandon Bowman, who's present to my right. You state your full name for the record, please.
Brandon Charles Bowman.
Today's date and time set for a probable cause conference. At this time, respectfully requesting you set this for an exam.
If I can address bond, Your Honor.
Okay. Are you going to address the additional bond violation report that we have? There's something else?
Yes.
Oh, lovely. All right. You want it set for exam?
Yes, Your Honor.
And you have the discovery.
21 call attempts to the victim after a no-contact order. Even if none connect, the law treats the attempt the same as actual contact. That's why this bond issue is about to get very messy.
To my knowledge, yes.
Would people have their witnesses available at 12?
I'll do my best, Your Honor.
Preliminary examination in person will be set August 12th, 2025, 9 a.m. before Judge Fresh Hour. As to bond.
Your Honor, I believe the defendant is in custody on a no contact order of bond violation originally. After he was put back into custody, he's tried to contact the victim 21 times. None of the calls have been successful, but he has tried to call her listed number in the police report since being put back in for violating the law.
And at this time, what's his bond? Is it revoked?
I have it as denied, Your Honor.
Yeah, that's what it should be. All right. As to that, Mr.
Your Honor, I haven't seen anything about these calls. My client is saying that
I have not made one phone call.
Your Honor, he's going to be asking for a PR bond. He's been in for 8 days.
Is the phone calls that he made, is that attached to his pen?
Your Honor, I'm trying to pull up my internet.
Okay. I understand you're saying that none of the calls were completed, but were they made from his pen? That's what I'm trying to figure out. Well, why don't we do it this way? Mr. Mulvey, you can talk to the prosecutor's office regarding that. If they did come from, I'm going to, at this time, I'll revoke his phone privileges. I will reinstate them if they did not come from his pen. Okay. So get with the prosecutor's office and I should have that answer as soon as their internet goes back up. All right, sir? All right. Otherwise, bond will continue as denied.
Your Honor, we have it pulled up real quick.
Oh, you do have it? Hold on.
They're from different pins.
They're from, are any of them his?
No, they're all different pins. There are 2 different pins that are being used, but not this.
And none of the calls were connected?
Correct.
All right. I'm going to deny the request then to have his phone privileges revoked at this time.
Your Honor, my client is asking for a PR bond. He's been in for 8 days.
I have a conditional bond violation. That's why he's in.
I understand. He's willing to admit to the bond violation and ask for the 8 days without a hearing. If
that I would not be sentencing him to the 8 days on it.
Understood.
I can tell you that. So does he still wish to admit to the violation? Yeah. Well, that's okay. Yes, I'm going to need one for your friend.
Okay. Understood, Your Honor. Then we'll keep it as it is.
Sorry. Once I check your big screen. Yeah, man, I'm just a figurehead.
Send on behalf of the people, Your Honor.
Covered on behalf of Mr. Amison, who's approaching the podium. Amison, please state your name for the record. Mario. So, Your Honor, there's a date and time set for probable cause conference. I was recently appointed, however.
100 calls since arraignment. Yes, you heard that right. In court terms, that's not persistence. That's a self-sabotage masterclass.
We are asking, I do not believe that there is video in this case, so we are asking that the matter be set for preliminary exam.
And if I could address bond, feel free, Your Honor.
Why am I not shocked? Okay. So you believe you have all the discovery?
I believe so, Judge.
Would the people have their witnesses available to 12?
We'll do our best, Your Honor.
Preliminary examination, August 12th, 2025, 9 a.m. That is before Judge Freshour. Yes, ask the bond.
Your Honor, it's come to my attention that Mr. Amison has called the victim in this case 100 times since his arraignment. So at this point, I would be asking...
What? 100 times?
100 times.
Okay.
So I would be asking that his phone privileges be revoked. It's her listed number in this report as well.
Response?
So, Your Honor, I spoke with Mr. Amison in the jail recently. We went over the no contact.
That wasn't on the phone, was it?
No, Judge.
My bad. Go ahead.
Technically, it was, Judge, because it was through the glass. So we did have a discussion on it. I explained that the no contact order, even if he receives contact from the complaining witness, he's not allowed to respond, or to, I don't know, I got it. Or if he is, even if she wants contact, it's my understanding that she does want the no contact order lifted, but we did explain what it means to have a no contact order in place. And going forward, I'm confident he will not be making any more contact and reaching out to the victim at all.
Excuse me,
Just
not talking, man.
What do you want to say?
She came and visited me, man. They let her come visit me, so it couldn't have been that serious of a non-contact.
So, we did discuss what the no contact order means. And so at this point, we are asking we're already set for preliminary exam. So, and the,
Say no domestic violence or nothing, man. This is fraud case.
we got it. It's my understanding that the complaining witness has reached out to him several times so that he didn't really understand what the no contact order meant. We've explained it. We've hammered down that no contact means no contact. So that at this point we are.
Let me ask this then. Other than those times where the defendant's alleging that the victim has come toward him, are the phone calls his calls out to her?
Your Honor,
Some are from his pin and some are from other pins.
Well, I understand that, Mr. Burdell, there might be a mix-up.
Here's the key. No contact means no contact. Visits, phone calls, messages through friends. It's all off limits unless a court changes the order. The defendant's, but she visited me defense. Legally irrelevant.
When she comes there and
I got one more thing to say, man. You ain't wearing it right, man. Excuse me, can I talk? I know how to talk. You feel me? I got you. She came.
Sure, go ahead.
She came to the jail to visit me.
I heard you.
I haven't seen nothing, and mail said no contact. How is she able to visit me if it's a no contact order and I'm in jail?
That I don't know, and that's why I asked if there were. I'm trying not to take those contacts where she's making them with you into consideration, because your attorney just explained that you had a conversation about how you have to respond to that.
Then they
So
told.
then I asked, were there phone calls from or contact from you to her, which would be strictly prohibited?
Right. Well, I was under the impression that I wasn't able to have no contact upon my release. They said during bond, we can't be in the same household. They never said about calling her from jail. This is not no domestic violence issue. This is a fraud for $30. That she clearly called the prosecutor and said she didn't want to press charges.
I don't know any of that, sir.
Like,
I don't.
because they telling you half the story, man.
I'm not going to get that information right now. I'm not supposed to have that information right now. Anything else, Mr.
No, Your Honor.
Anything else, Mr. Burdell?
no, Judge, not at this time. Thank you.
At this time, and this is only for the calls that he's making now, either from his own pen or from other pens, because that is not allowed and strictly prohibited. The defendant's phone privileges at this time are revoked. You can make the argument before Judge Freshour to reinstate them after the preliminary examination.
Thank you, Your Honor.
Thank you.
Man, you fired, man.
What'd you say?
You fired.
Come talk to him, Mario.
You just want me to go? You don't want me to go? You want me to stop on that and say something? You just want me to keep going? Really? Okay. All right. I'm gonna pick up the next one. And just... This is on your advice, because I got something to say, but I'm not going to. Court calls the case.